My name is Earl and I'm alright, and welcome to your family lawyer. Alright, remember that this is not legal advice, so what I get to share here is just legal opinion for the purposes of legal enlightenment, information, and understanding. So if you have any legal issue, I suggest that you speak with a lawyer so that you are able to get the proper legal advice for that particular matter. Thank you so much for joining me, and I want you to share this with your friends if you're watching live. And in case you're not watching live, you're watching the replay of this, I'll also want to share this with your friends so that they get to learn the same things that you are learning. Remember, I always say something, and I'm going to be repeating it today, that Hollywood, Nollywood, right, Bollywood, Gollywood, whatever wood they are not legal advisors. They are not necessarily educators for you to say, oh, I'm following them. I saw this in the movies, because we get to face that a lot. People consult the office, people consult with us, and you hear them saying, oh, I want to get a divorce letter, I want to get a divorce letter, I want to get a divorce certificate. My wife or my husband wants to sue me for divorce, but I'm not going to sign it. And I usually laugh, because whatever they are saying does not actually apply in reality. So Nollywood and the movies that you see, African Magic, are not legal advisors. So if you need proper legal information on a particular subject matter, always consult with your lawyer. Today I want to go straight into this conversation because I don't want to take all of your time, and I want to see how I can go through everything I'll be able to share today, and do that in the shortest possible time, right? You could drop your comments, you could drop your question, whether you're on Instagram or you're with me on Facebook. Kindly drop for these questions and I would answer them, right? Remember, if you drop your questions here, I get to answer them for free. But if you want to consult me through the DM or in my backyard or through the phone number showing on your screen, it will come with consultation fees. So today I want to mention the grounds for divorce, right? In case a person wants to divorce in Nigeria, what are the grounds? You don't just come to court and say, oh, I'm unhappy with my spouse, I'm no longer wanting to be in this marriage, I'm fed up with this marriage, and so I want to get out, or I think I'm done, I want to get out, and the court will just grant it. This is something that may be shocking to people, that the fact that you are filing a divorce petition does not automatically mean that the court will grant it. The court still has the discretion to grant your divorce petition or refuse it. Yes, there have been cases where the court actually refused divorce because the people who came for divorce did not come on the right grounds, in the sense that all their complaints, all their displeasure did not fall within the grounds for which they can seek divorce. Mind you, the law says that if you want to go on divorce, you should first of all seek counseling, right? In fact, your lawyer is required to file a certificate of counseling that he has counseled you people, or that you people have sought counseling and still decided that you wanted to divorce, right? So if the law requires that, the law requires then further that if you're coming to court, you should have these one or two or more of these grounds to say, this is why I want to divorce. Now, there are about 14 grounds for you to choose from if you want to divorce within 2 years of marriage. Generally, by our laws and by the principles of our Marriage Act, our Matrimonial Causes Act and rules, you cannot divorce from a statutory marriage if the marriage is less than 2 years. Now, what do I mean by statutory marriage? It means a marriage that was conducted in a licensed place or a licensed church for marriage or at the marriage registry. In a more legal way, we will say a marriage that was conducted under the Marriage Act, right? So if a marriage is based on that, you cannot file for divorce within 2 years. There are exceptional grounds, and those exceptional grounds are about 14. Here on Your Family Lawyer, I have explained, I have done a particular live explaining those 14 grounds on which you can choose to divorce within 2 years. However, let's assume that it's not within 2 years, or the marriage is already more than 2 years, and you want to divorce. What are those grounds that you must come under? In the sense that, what are those terms and conditions? What are those things you must actually bring to court and say, it is based on these things that I want to divorce? Because you cannot just divorce on anything, right? The law says that if you want to divorce on anything, rather go for counseling. So if there are 8 things for which you can say you want to divorce in Nigeria, and now, mind you, we are making reference to statutory marriages. That is, marriages that are based on the Marriage Act. Marriages that were conducted either in a registered church for marriages by a licensed priest, or marriages that were conducted at a marriage registry or any other place that the governor so licensed for that particular marriage. This conversation this evening is not for people who are married under customary law. It's not for people who are married under Islamic law, or people who are married under their different traditions and customs. It's regarding those people who have the federal government marriage certificate. So when people are confused and say, what type of marriage do I have? I usually tell them, show me the marriage certificates that you have. The marriage certificates that you have will usually give me a clue to know the type of marriage that you have. So if your marriage has Federal Government of Nigeria, Federal Republic of Nigeria, right, this is for you. This is for you. So let's go straight into the 8 grounds for marriage under the Marriage Act. 8 grounds for which 8 grounds for divorce, 8 grounds for which a person can come up and say, hey, I'm tired of this marriage and I want to leave. The first ground is that the respondent has willingly and persistently refused to consummate the marriage. Now, remember, the person who is filing for divorce in Nigeria is called the petitioner, and the spouse is called the respondent, right? Now, the first ground is the petitioner coming and telling the court that, hey, since we got married, my spouse has refused to consummate the marriage. What is consummation in our marriage and family law? Consummation means the first sex in a marriage, the first sex. So once two people have been married and they have never had sex, after a reasonable period of time, they have never had sex, it is a ground for divorce. There's something you should understand. It is not just that they have never had sex. It is that the one person in the marriage has refused willingly and persistently over a period of time, a reasonable period of time, to say, no, I do not want to have sex with you. So if the reason why they have never had sex in the marriage is because of a long distance marriage, or it is because of some health or other clinical issues, these grounds will not work. It will not fly for you to come to court and say, we have not had sex in our marriage. No, it must be that one spouse, in this case the respondent, has willingly, willfully and persistently over a period of time. That period of time could be 1 month, 2 months, 3 months, 4 months, 1 year, refused to consummate the marriage. And the reason why the person is refusing to consummate the marriage is not based on some clinical issues or some health issues or some distance issues. I remember one particular case several years ago. This may be 2012, December 2012, if I'm not mistaken, that my office handled that particular matter. No, it was not a matter. I was in court that day for another matter, and I witnessed this case. Was the fact that the woman said that since they have been married, the man had refused to share the same bed with her. She's always complaining that her body is too hot, this and that. She has gone to appeal to his family. She has gone to appeal to people. She has done everything possible to see how they could have sex together. She has reported him. She has sought counseling, but the man has refused to have sex with her. So that is willingly and persistently, right? Of course, there was no clinical tests or assessments done to determine whether it was a health issue, but the fact that he was not making any move whatsoever means that he was willingly and persistently refusing to consummate the marriage. Now, if the couple have had sex once in that marriage, maybe perhaps penetration happened but ejaculation did not happen, or orgasm did not happen, this particular ground will not fly. Right? Take note of that. It will not fly. The moment penetration of the vagina has happened with the penis, right? There have been coitus, right? Vaginal sexual intercourse, then consummation has happened. So the first ground for divorce in Nigeria is that the respondent has willingly and persistently refused to consummate the marriage. Remember that if you have questions, you can drop them in the comment section, and I, yours sincerely, will be the one that will respond to them. So let's go to number 2 as to another reason why, another ground for divorce in Nigeria. The second one is that since the marriage, the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent. Okay, adultery is a major grounds for divorce, right? Okay, we do know that in certain part of Nigeria, generally Nigeria is divided into north and south. When we are talking about certain parts of Nigeria, we are saying certain part of Nigeria, we are talking about the southwest, the south-south, and the southeast. These 3 regions form the southern part of Nigeria. Then we have the northern part of Nigeria, right? The northeast, the northwest, and the north central. Now, when it comes to the southern part of Nigeria, adultery is not a crime. Adultery is not a crime. However, adultery could be a civil wrong. And in situations where adultery is a civil wrong, it is usually the man that can claim compensation, right? It is usually the man that can claim compensation in southern Nigeria. But in northern Nigeria, adultery is a crime. Is a crime, whether it is committed by a man or it is committed by a woman. Now, the second grounds for divorce is that in the course of the marriage, the respondent, the petitioner, is not saying, that is the person who comes to court to file for divorce, to ask for divorce, to file a petition for divorce, is coming to say that, hey, in this marriage, my spouse has been adulterous. My spouse has committed adultery, and it is not something that I can take. It's not something I can condone. It's not something I can live with. Right? Let me say this before we move ahead, that in case you do not know, apart from being a family law lawyer, I'm also a marriage and family life counselor. And right now, I'm already done with my academic works in achieving my certificate of counseling psychologist. That is a master's degree in marriage and family life counseling, University of Ibadan, Nigeria, right? So I'm already done with my academic work, just remaining my research work, my research project, and I'll be awarded counseling psychologist, Masters of Education. All right, so I'm also in marriage and family life counseling. And so let me put this here, that I know many marriages that have recovered from infidelity. If I want the services I render is infidelity recovery therapy. However, by law, a person can say, my wife or my spouse has committed adultery and I cannot take it. I cannot accommodate it. I cannot forgive it. I cannot let it go, and I want to divorce this person. It does not necessarily have to be more than once. Once the person is bringing it in, then yes. Once the person is bringing it up, and the person can prove the adultery, it is a sufficient ground of divorce. Adultery is sufficient ground of divorce in Nigeria. Yes, thank you, Amzis, that is asking me on Instagram. Where am I in Nigeria? I am in Ibadan. I live in Ibadan and I'm doing this live from the city of Ibadan. Then, regarding your question, I'll quickly want to drop an information. Remember, this is not legal advice. This is just legal opinion for the purposes of education and enlightenment, right? When it comes to marriages under the Marriage Act, so when it comes to marriages that are based on the Marriage Act, which may be conducted in at the marriage registry or in a church that is registered for marriage, Nigeria is one jurisdiction. What that means is that you can marry in Lagos and choose to do your divorce in Owerri. You can marry in Owerri and choose to do your divorce in Manduguri. In fact, when it comes to marriage and divorce under the Marriage Act, that is for people who their marriage certificate carries Federal Republic of Nigeria, the Marriage Act, right? Nigeria is one jurisdiction. Nigeria is one place. So you can do the divorce anywhere. The exception is that your spouse can oppose to it based on the distance and based on convenience, but you can actually do your divorce anywhere in Nigeria, no matter where you did the marriage. The Marriage Act is a national statute and is the law that guides marriage and governs the full country. So let's go to number 3. Ground for divorce in Nigeria. That since the marriage, the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. You see, this is more or less like an omnibus clause. Like it's like it's general. This person has behaved in a way and in a manner that it does not make sense, and it's unreasonable for any person to tell this person to continue in a marriage. One example I can give right away, I handled that particular case, was the fact that the man was not wanting the woman to have children. The man did not want to have children. I don't know whatsoever it may have been their conversation while they were single. And this is why, if you're single right now and you're watching this, kindly ask your partner, do you want to have children? And agree on that, because there are some people who do not want to have children. So in this particular case, obviously the man did not want to have children, and for every time the woman was pregnant, he would always require her to go through abortion. And by the time on this particular occasion, she refused to have an abortion because she had already had about 3 abortions and she was married. Everybody, the in-laws, the community, society, everyone was wanting her to have children. And she too, she desired to have children of her own. And the man told her that, okay, yes, I agree for us to also have this child. And let me go and register you in a particular clinic for your antenatal, not knowing that the man had arranged with the doctor to inject her so that she would have spontaneous abortion. So by the time we were in court, the man had made her have about 6 to 7 abortions thereabout. And so in that situation, the law says that since the marriage, the respondent has behaved in such a way and manner that the petitioner cannot reasonably be expected to live with the respondent. In that situation, it's not reasonable. Like, this woman wants kids, this man does not want kids. It's not reasonable for you to expect them to live together when the man is always pushing for an abortion. All right, always pushing for an abortion. So that's more or less like a general ground and omnibus clause that covers many other things that the law would not ordinarily have envisaged. I have seen a situation where a man has refused to live in the same house with his wife. He had refused allowing the wife to move over from the city where she was living to join him, and he had refused to move to join her. He wanted a long distance marriage, which defeats the purpose of marriage generally. So on that, you can come to court and say, I don't want this marriage again. I'm not doing this marriage again. I don't want to have anything to do with this marriage again. So that also applies. The next thing I want to talk about, because I don't want to take all of your evening, remember that we are going to 8 things and we are still in number 3. So I quickly want to jump to number 4 so that we rush. Many of us are parents and we want to have help our kids with their assignments before it is bedtime. So allow me do this rush. The next thing I want to talk about is that, which is number 4, is that the respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition. Right? Now, the respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition. Okay, let me explain this. And it's something I've explained before if you are one of those who gets to follow me, right? Remember to drop your questions in the comment section if you have any question. And please do me a favor, if you are not following yet, if you have not yet subscribed, if you have not yet joined, wherever you may be watching, whether you're watching this on Instagram or you're watching this on Facebook or you're watching this on YouTube, kindly do so that you don't miss the amazing content that I get to produce every day. Now, if you've been following me for a while, you understand something that I've always explained, that there's a difference between separation and desertion. Now, what many Nigerians are calling separation, oh, I'm separated from my spouse, oh, I will separate from my spouse, is actually called desertion of marriage, right? Because separation, your marriage is a legal institution. It's a legal institution. It's a statutory institution. It was created by law. The two of you did not just enter and start living together. No, you followed legal process and you were declared man and wife. And so that became a legal union. For you to leave that marriage, whether it is by divorce or what you call separation, it has to also be in accordance with what the law says. To law, it has to be accordance to the law, right? And the law says that if you pack your things and move out of your house, of your matrimonial home, it is desertion. It is not separation, because separation ought to be declared ordered by a judge. For you to be separated, the judge has to be. That's how it's called legal separation. Declaration of separation, legal separation. It is a judge that is supposed to separate you, not you just decide to say, I'm packing out and I'm leaving. Right? So when you pack out and you leave your matrimonial home and you have done that for at least 1 year, the other party can go to court and say, hey, I want to leave this marriage because my spouse has deserted this marriage for at least 1 year. So it is desertion of marriage. It is not separation, right? Separation must be ordered by a court of law. By a competent court of law. I know this may shock you, but that's just the reality. If you walk out of your marriage without getting a formal legal judicial separation, that is desertion of marriage, and it is a ground of divorce if you have done it for a period of up to 1 year. Okay, let's continue. The next thing I want to talk about is that the parties to the marriage have lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition, right? And the petitioner does not object to the decree of dissolution. Now, you must understand the difference between this and the previous one. The previous one is that you walked away from your marriage. This one does not mean that you walked away from your marriage, but it means that the two of you have been living separately apart, maybe in a long distance relationship. One person is in the UK and the other person is in Nigeria. One person is in Anambra and the other person is in Abuja, right? You guys have lived separately for 2 years, not necessarily because one person walked away, but two of you have lived separately, and right now, A is asking for a divorce and B is not objecting. Notice again the difference. The first one is that one person walked away, desertion of marriage. Many people call it separation, no, but it's desertion of marriage. One person walked away. The second one is long distance marriage. Long distance marriage in the sense that you have been living apart. One, the conditions are 3. 1, you have been living apart. 2, you have lived apart for a period not less than 2 years. And 3, one person is asking for divorce and the other person is not objecting. So that if the other person objects to it, then this ground becomes 40. Very 40, right? So let's go to the next one. So let's go to 6 right now. 6 is that the parties of the marriage have lived apart for a continuous period of at least 3 years immediately preceding the presentation of the petition. Now, notice the difference between the 3 things. The first one is that one person walked out of the marriage. For that one, which is desertion of marriage, you just need 1 year. The second one we talked about was that the 2 people have lived apart, that is, they have lived separately for 2 years, and that the 2 of them are not objecting to the divorce. The third one is that the people have lived separately for 3 years. Now, when you have lived separately for 3 years, the other person cannot object. If it's just 2 years, the other person can object. But if it's for 3 years, the other person cannot object. The other person cannot say, no, I'm not agreeing to this. No, I think we can still work on our marriage. No, I think we still need to talk with our counselors or talk with our family members and see a headway. But once it's 3 years, forget it. No. This can no longer work. Right? So that's it for number 6. Then for number 7, is that the other party to the marriage has for a period of not less than 1 year failed to comply with a decree of restitution of conjugal rights made under the Marriage Causes Act. Matrimonial Causes Act. Let me explain this. Remember when I was explaining desertion of marriage, I said if you walk away from your marriage, it is desertion of marriage. It is not separation. Because separation has to be judicial, has to be legal. A judge has to order it, right? So if a person is separated from his spouse right now and it is not based on a court order, it is desertion of marriage. Okay, now, when a person deserts from a marriage, or maybe the person is even inside that marriage, but the person is not performing his matrimonial duties, their matrimonial duties, we'll talk about that on another day, right? We call them marital rights. Over in counseling, we call them marital rights. When it comes to marital rights or matrimonial obligations, if a person is refusing to perform those duties and those obligations, the court can order that person to do so, right? For example, if somebody walks out of the marriage, the court can order that the person returns back to the matrimonial home, or the person returns back sex, or the person returns cooking, or the person returns providing, right? If after the court has made that order and the person fails to obey that order, and the person fails to do that for 1 year, it is a sufficient grounds for divorce on its own. Sufficient on its own. That's what that particular provision is talking about. Besides, let me mention that everything that I've been reading and everything that I've been saying is based on section 15 of the Marriage Act, of the Matrimonial Causes Act, right? So based on section 15. So if you go to section 15, you'll be able to see all these laws. You'll be able to see everything that I am saying. All you just need to do is to go to the Matrimonial Causes Act. It's available online, right? It's available online, so you can find it, right? You can find it there. Okay, let me continue with our G. So bang, 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 bang. Okay, which will be number 8. Oof. 1, 2, 3, 4, 5, 6, 7, 8. So number 8 is that the other party to the marriage, which in this case is the respondent, has been absent from the petitioner for such time and in such circumstances has to provide reasonable ground for presuming that he or she is dead. This is what we call the presumption of death. The presumption of death is that for so number of years, I have not seen this person, heard from this person, or heard of this person. So I want to assume that the person is dead. We have seen it a lot, where somebody say, for the last 3 years, I don't know where my spouse is, I don't know where my husband is, I don't know where my wife is, I've never heard from him, I've contacted the family, nobody knows where he or she is. So once he's over a particular period of time. There's actually a number of years, 7 years, right? And this person 5 to 7 years, and we have not heard from this person, the law brings in what we call the presumption of death. The presumption of death is that we can safely assume that this person is dead. 1 year is not sufficient. 2 years is not sufficient. 3 years is not sufficient. Remember that this is not legal advice, right? This is just legal opinion to educate you and enlighten you on the grounds for divorce in Nigeria based on the Marriage Act. Everything I have explained thus far does not affect customary marriages or Islamic marriages. It only affects marriages that have the Federal Republic of Nigeria certificate. So I'll go through all the 8 things that I mentioned, right, and wrap it up. So number 1 is that the respondent has willingly and persistently refused to consummate the marriage. And number 2 is that since the marriage, the respondent has committed adultery and the petitioner cannot condone it, right? The petitioner cannot tolerate it. Number 3 is that since the marriage, the respondent has behaved in such a manner that the petitioner cannot reasonably be expected to live with the respondent. And not just that, number 4 is that the respondent has deserted the petitioner for a continuous period of 1 year. I explained this earlier on because number 5 is also unique, which says that the parties to the marriage have lived apart for a continuous period of at least 2 years, immediately preceding the presentation of the divorce petition. Then next, we said that the parties, right, we also went further to mention, okay, my Instagram followers. Let's see. Okay, reconnecting for my Instagram followers. We had a little bit switch there. Let's go. We are back. Great. So now the next one we talked about was that the parties to the marriage have lived apart for a continuous period of at least 2 years, right? And from there, that the parties to the marriage, they have lived apart for a continuous period of at least 3 years, immediately preceding the presentation of this petition. I explained all of that. Okay, we went further to talk about that the other party to the marriage had, for a period of not less than 1 year, failed to comply with a decree of restitution of conjugal rights made under the Marriage Act. And we talked about that the other party to the marriage has been absent from the petitioner for such a time and in such circumstances as to provide reasonable grounds for the presumption of his or her death, that he or she was dead. In all, everything that I've said, everything that I've been trying to say since the beginning of this video till now can be summarized under one thing, and that one thing is that the marriage has broken down irretrievably. So the sole and one ground for divorce in Nigeria is that marriage has broken down irretrievably. And in proving that marriage has broken down irretrievably, you have to prove one or more of these 8 things that I have mentioned. Family and friends, I cannot take all of your time, so I have to go right now. If you need further legal advice, further detailed explanation, you may want to use the details showing on this particular video and contact me, because I'm also a lawyer. I'm a family law lawyer of 12 years. And interestingly, I'm also a marriage and family life counselor and therapist, and I've been doing my counseling and therapist practice for about 19 years, right? So if you send me a message, I'll be able to give you proper legal advice, because it's not legal advice, it's just legal opinion. And if you don't want to contact me, I suggest that you consult with a lawyer before you make any legal decision regarding your marriage. I'm reaching you from the ancient and the modern city of Ibadan, Oyo State, Nigeria. Thank you so much for following me. Subscribe, like, follow, right? Join wherever you may be watching this from, and share this with your followers and with your friends so that they get to learn the same things that you are learning. My name is Earl and I'm all right. Thank you so much. You rock.